Okay, well, welcome everybody. Thank you so much for joining us today. We'll go ahead and get started. My name is Amos Irwin. I'm with the Law Enforcement Action Partnership. And yeah, we're very excited to have you here with us. I will dive right in to introducing the panelists. But before I do that, just so you know you're in the right place, this is our webinar on legal liability for community responder programs. So with that, we have three distinguished panelists with us today. Sofia Hernandez is a deputy city attorney for the city of Durham, where she's researched liability questions for the Durham HEART program's community response teams. And she also teaches at the Duke University School of Law. Kurt Gosselin is an associate in the Consumer Financial Services Data and Technology Practice Group at Akerman LLP. He was the lead researcher for LEAP's Community Responder Liability Report as part of a pro bono team from Akerman. And Jay Fisher is a firefighter and paramedic with 2 fire departments in Colorado. He has previously served as an assistant attorney general in Colorado and a senior assistant attorney general in Georgia. He consults with cities on legal liability for fire and EMS. And Jay is currently on call with the fire department during this webinar. So if he disappears all of a sudden, you will know what happened. Now, before we dive in and actually get to hear from the panelists, I wanted to quickly define what we mean by a community responder program, since we have a very specific focus for our conversation about legal liability. So there are different types of alternative response programs. This webinar focuses specifically on community responder programs. To define that term, a community responder program is an unarmed team that a call center can directly dispatch to provide a first response to low-risk 911 police calls for service. So a team would not qualify as a community responder team if it included a police officer, or if it didn't provide first responses but just followed up after police had already cleared the scene, or if it didn't handle 911 police calls for service. So with that, jumping into what do we have ahead of us? What's going to happen in this webinar today? This webinar has 2 parts. First, we will discuss key content from the LEAP liability report, including police liability for answering 911 calls, community responder liability, new federal statutory claims under the Americans with Disabilities Act, and advice on liability protection. And then second, we will cover audience questions that were asked in advance, and a big thank you to everyone who submitted questions. I mentioned this before, but we will not be answering live audience questions that come up during the webinar, but we do want to encourage audience members to ask questions that we can follow up on later. So please, you can ask questions in the chat. Better yet, email it to liability@lawenforcementaction.org. It doesn't need to be a question. You can email us feedback, something we missed, something that's happened in your own jurisdiction, or other comments. We are very excited to keep the conversation going. And we will be recording this. If we will do our best to provide a recording to everyone. So hopefully next week you will be hearing from us with a recording, but no guarantees. Before we dive into the content itself, Kurt, would you please start us off with a disclaimer?
Yeah, absolutely. Thank you, Amos. So we'll be giving you a presentation today created in part by one or more attorneys. It's important for you to understand that the attorneys presenting are not your attorneys, and nothing in this presentation should be interpreted as legal advice. The presenters, by speaking to you, are not creating an attorney-client relationship between you and them, or between you and my law firm, Akerman LLP. The information provided in the presentation does not and is not intended to constitute legal advice. Instead, all information is for general informational purposes. Our laws, the court's interpretation of our laws, can change day by day. The information in this presentation may not be the most up-to-date legal or other information. We recommend that attendees contact an attorney to obtain advice with respect to any particular legal matter. You should not act or refrain from acting on the basis of information provided in this presentation without first seeking legal advice from a lawyer who has all the relevant details relating to your particular situation. Only your individual attorney can confirm whether the information presented and your interpretation of it is applicable or appropriate to your particular situation. And the views expressed by the individual presenters here are in their individual capacities only, not those of my law firm Akerman or any of the partnering or affiliated organizations.
Sophia and Jay, would you like to add anything to that fabulous disclaimer?
I don't think there's anything else to add. Thank you so much, Kurt, for that very well prepared disclaimer.
All right, we'll see you around then. Thank you.
Wonderful. So, Sophia, as someone working within city government, I'm hoping before we dive into the content, you can say a few words about why these liability questions are important.
Sure. Yeah. I mean, I think, right, cities provide services to its residents and its visitors. But especially in North Carolina, I can speak to what those services look like or what even those services are up for the cities to determine. Unlike parishes or counties, there's not this long list of mandated services cities have to provide. And so there's freedom there to decide. Of course, many of the services cities already provide have existed for decades, if not a century, right? Police, fire, 911 answering points have existed for 60 years. However, when we're talking about new services, when it comes to analyzing what are the costs and the risks of those new services, there's not always an easy comparison because that service doesn't exist perhaps elsewhere. There's no clear laws on the books or cases in which judges or juries have decided these key issues of liability. And that's what we have found, of course, is to be especially the case for these community responder services. Most cities have never before hired a mental health crisis provider or provided substance abuse services or harm reduction services. They've never hired clinicians or contracted out for clinicians. So those are all new questions that face these municipalities or counties. Determining costs requires looking at risk. Can you provide the services legally? Can you do so safely and not open the city to suits or, run the risk of harming residents? Will insurance cover the city? Those, again, are all these questions that the cities have to engage in and wrestle with when determining whether to take on a program like this. And cities do need to undergo that kind of analysis because it's the responsible thing to do when you're determining where we're putting the limited amount of public dollars, right? Money for cities and counties is limited, and we have sort of that responsibility to our constituents, to our residents, to our populace to do so responsibly, to spend that money, to be good stewards of public dollars, and we're accountable to the populace.
Thank you so much. So with that motivation, we will dive in first to the section on the content of the report. So Jay, I'm hoping you can discuss the existing legal liability risk of sending police to handle low-risk 911 calls.
Sure. The sort of the 800-pound gorilla that's been hanging over liability with police departments and in terms of responding to 911 calls generally, whether they're high risk, low risk, any risk at all, has been what's called 1983 claims. Those allow people to sue government for civil rights violations under a section of the federal code 42 USC 1983. Really, to very much simplify the elements of this, what this is saying is that a party acting under the color of either state or local law deprive another person of rights created under either the United States Constitution or by federal statute. The most oftentimes this is invoked is when a person is subject to excessive force by the police. One of the big gray areas that's involved in public safety work generally, but especially true in police matters, is what is an officer walking into when they respond to a 911 call. you just really never know in any situation. You might be dealing with someone who might be a homicide suspect, and they basically respond very peacefully to commands and follow the orders of officers. You could respond to a lower level situation of someone just acting erratically, and the whole situation devolves down into one of a great deal of violence by everyone involved, and maybe even lethal violence. Something to be kept in mind here is that the 1983 action is a federal action. Depending on the state a person lives in, the states could even provide their own state causes of action, depending on the structure of the law and the state constitution, et cetera. So it's very jurisdiction specific. And therefore, if someone's going to try and address civil rights violations, they have to be aware that not only is there a federal component, there could be a state component as well.
Thank you so much. And I know there isn't great data out there. One source that we're aware of, a Washington Post investigation, found that the 25 largest law enforcement agencies alone pay about $300 million every year to settle lawsuits, and many of them related to 1983 claims, as Jay mentioned. So we wanted to give that brief backdrop, talking about sort of the status quo in what cities are facing right, in the past, even before they set up a new program. Kurt, I'm hoping that you can speak about legal liability for community responders.
Yeah, absolutely. Thank you, Amos. And just as a forewarning to everyone, this may be sort of the longest stretch of just one person talking of the presentation today, so please bear with me. But as Sofia noted, because community responder programs are relatively new, there's little case law out there specific to actions taken by community responders as the program's envisioned, how Amos described it at the top of the presentation. In fact, we didn't identify any cases specific to community responder programs during our research for the liability report. So instead, we were researching cases in which cities were sued for actions of other first responders that could be plausibly taken by community responders in a community responder program. We also looked at how different states approach municipal liability in terms of their statutory schemes. And generally speaking, we found that state tort claim laws or state tort claims rather, are likely to pose the greatest risk for municipal liability for a community responder program. So I know we have a diverse array of experiences on this call, including lawyers and non-lawyers, state and city practitioners, law enforcement, policy folks, people in the advocacy space. So I want to start with a very brief general overview of state tort law, and then can get into specifics of what we found. And I also want to preface, generally speaking, I will probably use the term city and municipal interchangeably, and that should not signify any distinction between those two terms. And also note that many states we found also apply similar principles to counties and other local governmental subdivisions. So the use of these terms shouldn't to signify the inclusion of one to the exclusion of others. But in brief, a tort claim is a claim that someone or some entity committed a civil wrong by either acting negligently or intentionally in some manner that injured someone. Private citizens and entities have long been subject to tort claims for actions, but historically, state and federal government enjoyed immunity from tort claim actions. Yet over the last 100 to 150 years, many states, as a matter of public policy, provided for limited tort claim exposure against the states themselves, and in many areas for municipalities. Most have done so by passing some version of a Tort Claims Act, defining the areas where states or cities can face liability. But there are also carve-outs in most states under the common law, or areas of law historically where courts have permitted an exception to the policy of state or city immunity from claims in particular areas without necessarily a statute defining that. One of the biggest areas that we found And I understand one of the most common questions that's been posed by practitioners who are considering community responder programs is what liability might a city face if a responder is dispatched and then they're either unable to prevent harm occurring to a distressed individual, or if that individual then proceeds to harm someone else, this concept of failure to prevent harm. And although the specifics vary from state to state, we found that typically cities are protected from tort liability for first response activity. Generally, to prove a tort claim, in the ordinary instance, a plaintiff must prove 4 things. A defendant, here a city or city employee, owed that plaintiff a duty. The defendant then breached that duty, typically through some negligent action or inaction. The plaintiff suffered an injury, and it was the defendant's breach of the duty that was the cause of the injury. The classic simple tort, so not in the government case, but a classic simple tort is the store owner who fails to maintain sort of the entryway to their storefront. For example, fails to clear ice from the entryway in the winter, and a customer slips and falls and gets injured. The defendant store owner owed a duty to ensure its customer had safe access to the property, breached that duty by their negligence to clear the ice, and the customer is injured as a result. In the municipal liability space, however, courts have long applied a different test to government action than to the action of a private individual or private entity. More specifically, courts have recognized this concept of what's called a public duty rule. So where an individual actor in a traditional tort case, like that store owner case that I provided, may owe a basic duty of care to an individual attending their store, when the government chooses to undertake the provision of government service, think the offering of fire safety services, for example, it owes a general duty to the public at large and not to every individual citizen in their unique circumstances. This is why, for example, cities don't regularly get sued when houses burn down. The city doesn't owe a duty to the individual property owner simply by having the existence of a fire department. This concept also applies to first responders in most states.
All right.
Generally, there's no duty to prevent harm to a particular individual. So where a community responder is dispatched to an incident, their failure to prevent harm to the individual or prevent that individual from harming someone else without more typically will not result in liability for a city. With no duty comes no liability. This is where the favorite lawyer thing comes in. However, there are a few courts, though they're in the substantial minority, that found exceptions in rare circumstances to this general duty concept. And it usually occurs where there are a bunch of additional facts that give rise to a specific duty to the individual as opposed to the general duty to the public. One of the cases we cite, and we cited a few times in the report, is DeLong versus County of Erie, a case out of New York. And in DeLong, the court found that taken collectively, the following facts were sufficient to raise a question of fact as to whether the city established a specific duty to the individual victim so as to have a requirement or a duty that they prevent the harm. The facts that the court considered here were the city provided a 911 number. The dispatcher who responded to the call promised to send an immediate response. The dispatcher specifically recommended the caller stay in the immediate area of danger, despite knowing danger was present. The caller then relied on this recommendation from the dispatcher to stay in the area of danger. The dispatcher then sent no police response at all, and the caller ended up being killed by the source of danger while awaiting for the response. So the court considered those essentially 6 factors in making its determination. And to be clear, the court didn't hold that did create a specific duty, just that there were enough facts that a trier of fact, either the judge later, once all the evidence was presented, or a jury could consider that, that it might rise to a level of an individual duty. So one other area sort of conflict or complication in the space is the concept of government function. Many jurisdictions apply different standards to government functions as opposed to proprietary functions. Courts historically have considered services like 911 response, fire protection, and police as government functions. Many states have specifically codified these services as government functions in their statutes, whereas proprietary functions are the types of functions where government engages in activities that compete directly with private business. However, not all jurisdictions draw the same lines. So one example that we cite prominently in the report as an exception to this rule is the Washington State case of Norg versus Seattle. There, the court did find that operating a 911 call system and accepting 911 emergency calls was a government function. However, once the city decided to undertake the act of providing an emergency medical response, the public duty rule no longer applied because the emergency medical response or emergency medical assistance is not a unique function of government. And then Washington's statutory scheme only provided public duty protection for governmental duties. So once the medical response occurred, that then ordinary negligence applied. It was no longer considered a public duty. That's kind of the high level overview of the primary areas that we researched. We did identify a few other areas of potential liability, most notably in the setting of vehicle operation. Nearly all states provide tort liability for negligence in vehicle accidents caused by city employees, and this is often by statute. So this applies kind of across the board. This isn't unique to community responders. In fact, this often applies to police and fire as well, except in some states for particular emergency situations or like sirens on situations. And our research suggested that this, in fact, community responders driving their vehicles or driving city vehicles would be one of the most likely scenarios for potential city liability. I also want to talk briefly about the concept of gross negligence, because that's the other place where outside of the public duty rule, where cities may face liability from community responders. Though the precise language varies from state to state, most formulations of what constitutes gross negligence include some version of reckless and or wanton conduct in their definitions. For example, the state of Wisconsin, the common law permits liability where a city employee, quote, deliberately ignored an obvious and hazardous danger. Illinois Supreme Court has described such conduct as demonstrating, quote, utter indifference to or conscious disregard for the safety of oneself or others. So even though liability can be had by cities for responders committing gross negligence in their actions, it's important also to note this is a very high bar to meet. For example, in a California case, there were 911 dispatchers were found to be not grossly negligent when they dispatched emergency personnel without any emergency equipment, where the resulting emergency equipment would have saved an infant who otherwise suffered lifelong debilitating injuries for not having the proper equipment. And in a Michigan case, 911 dispatchers were not grossly negligent when they assigned an inappropriately low priority level to an otherwise urgent call, waited over an hour to send police, and the victim ultimately died, likely as a result of the time delay. So it's a really high bar to hit gross negligence. But however, not every state is the same, which is one of the common themes in the report. In fact, at least one state, West Virginia, for example, lumps in reckless acts with intentional torts or acts of malice and actually assigns liability there to the individual and not to the municipality for gross negligence or for reckless acts. Of course, it's important to note that even if a city doesn't face liability ultimately, cities often provide for the defense of city employees in these lawsuits, which can incur time and expense in addition to public relations issues. Lastly, before I turn things back to Amos, I want to note there are other provisions in these state statutory schemes we've seen where the cities may not face liability risk, but they do have additional procedural protections that can benefit the cities. These often show up in two forms: damages caps and presentment and commencement procedures. Most states have some sort of either per person or per incident damage cap. Many are in the kind of $100,000 to $250,000 range. though almost universally states allow claims in excess of these ranges up to the level of insurance that a city has for such claims. I should note that at least one state, Virginia, though, does not have a cap on their individual tort damages. And the other limitation is presentment and commencement. Though it's not a limit to liability, many states require some form of exhausting administrative remedies before a lawsuit can be filed. And that includes usually notice to the relevant city unit and awaiting a decision from the unit about a claim. And that this timeline is often required within 6 months to a year of the incident happening. So if a potential plaintiff doesn't move quickly, they can be barred from bringing their claim. And likewise, statutes of limitation, or the time period in which a lawsuit can be brought, are often much shorter for claims against cities than against private individuals. Most states we saw have requirements in the 1 to 3 year range, after which claims would be barred in their entirety, regardless of their merit. So I know that was a lot. That was a very high level overview of the report takeaways, but Amos, I'll send it back to you.
No, thank you so much, Kurt, for condensing months of research into not just the report, but a really brief overview of the bulk of the the meat of that report. So I wanted to turn now to Sofia. If you could please explain the recent ADA lawsuits and what they may mean for cities with and without community responders.
Yeah, absolutely. And yes, thanks to Jay and Kurt for sort of laying out what the avenues that we think of with source of liability for community responders. And I think that has folks sometimes a bit like, hey, let's keep the status quo. We know what to expect. But from our perspective, we wanted to highlight the lawsuits that are kind of nudging folks to actually think about taking on these community responder programs, because there are a few lawsuits out there that are arguing the status quo is a violation of the ADA and the Rehabilitation Act. So 2 suits in particular that I wanted to note, and one is Bread for the City v. DC. That was a lawsuit filed last year. The ACLU is kind of heading that up. It's the plaintiff arguing that by 99% of the time when someone has a physical health crisis, folks who are sent are folks who are trained to deal with those physical health issues, as compared to when someone is suffering from a mental health crisis. 99% of the time in DC, they're getting someone who is not trained to deal with those specific needs. And so the plaintiff argues that disproportionality is in fact a violation of the ADA and Rehabilitation Act, because the ADA and Rehabilitation Act says that you cannot exclude a person with a disability from participating or getting benefits of a program equally as opposed to folks with non-disabilities. You have to sort of offer equal opportunity to enjoy and to participate in programs to folks with qualifying disabilities as you do the general populace. And so the ACLU makes this very compelling argument in like a 47-page complaint. I do suggest folks, if you want a good read, to check it out. And so a similar case a few months later was also filed in Oregon, and that was against Washington County. But again, the same claims that the not providing mental health response to folks in undergoing mental health crises was an unequal provision of services and violated the ADA and Rehabilitation Act. So we've been keeping an eye on those in our office, interested to see how they were going. As you can imagine, there have been a ton of filings. The police union decided to, join in to object to the case. The DOJ filed a statement of interest in these cases. The DC filed a motion to dismiss the case, arguing that no, this is not unequal services. What you're asking us is in fact to either provide a higher standard of care or to provide wholly new services. So really, this isn't a violation of the ADA or the Rehabilitation Act. So those arguments were presented to the court in DC, and just in September, the court decided that this does fall under the ADA and the Rehabilitation Act, and asking folks to asking the parties to actually brief their arguments or present their arguments. So I think the fact that the case wasn't dismissed is opening the door to more of these suits. Similarly, in Oregon and Washington County, the magistrate judge who considered the motions to dismiss also said, hey, this could in fact be a violation of these laws. Let's let this case proceed. So we wanted to highlight that because just when we're thinking about, lawyers especially, right, we're very risk averse. And so when our departments come to us or our clients come to us and say, hey, we want to do this whole new thing, it's kind of easy to say, let's not. There's too many unanswered questions. I think what these suits show is that there's also some danger in not doing this. Obviously, the DOJ with, I think, Louisville, Minneapolis, and more recently Phoenix has issued some pretty important investigative reports in which the DOJ has also said, hey, you're discriminating against people with behavioral health disabilities when you dispatch just police or regular EMTs who are not trained to deal with those instead of providing folks who are trained to deal with those particular emergencies. And so we're keeping our eyes open and seeing what those cases result in or what the settlements might result in, because I think it could answer some of these questions that we have not yet had answers to because there hasn't been any case law.
Thank you so much. And finally, to complete sort of the content largely within the report itself, if you can cover advice on how cities can protect themselves against legal liability for their community responder programs.
Sure. And I guess when we say the word advice, I want to hit back on that long disclaimer, right? No, I mean, I think that some avenues, which I have seen and engaged with other colleagues in other municipalities, that they go about ensuring how they want to protect their own cities from liability, and certainly things we've done in Durham. Three things that I wanted to highlight: policies, right? If you ultimately decide that you do want to have some community responder services within your city or municipality, ensuring that you have good policies that are reviewed by legal, that are reviewed by HR, that are reviewed by risk, all the players that are important to review these policies. Right? Because you need things that guide how are you going to provide these services? How are you going to try to minimize negligence or other things that could come up to open the door to liability as well as harming residents? How do you ensure confidentiality now that you may create, you have clinicians on board and you've never had that and they're engaging and getting information from residents that you've never collected? Do you need some new way to collect information, to protect information? Policies need to guide that. And then you need to onboard your people on these policies, and you need to have folks who uphold and enforce these policies, right? Because policies on their face can just be empty words if you don't have training and accountability on those policies. So for me personally, I consulted on several of the policies of the Durham Community Safety Department. And certainly we're in our almost 2.5 years now. We've done a lot of revisiting of those policies, right? And tweaking them, because you need to be flexible in your policies as well when you're starting a new department, because what you know before you start, once you start, and 2 years after your start is drastically different. And so yes, have good policies, but revisit them to be able to make tweaks as you learn the needs of your residents, as you learn the potential and capacity of your staff, as you get reactions and feedbacks from the public and your policymakers. So definitely policy. The next thing I wanted to highlight is insurance. That is not a very jazzy conversation, and I can't say that I know all the particulars about our insurance policies, but we in the city of Durham have some great risk management folks. And so talking to them, being friends with them to ensure that in this expansion of service, you're still covered by insurance coverage the way that the city administration wants to be, right? We also just talk to risk about, because they think about everything. They even think like things lawyers don't even come up with, right? So we talk to them and they're like, what shoes are these folks going to wear? What are the locking mechanisms on your vehicles? And frankly, that hadn't occurred to me, right? So it was great to talk to them because they're thinking about how do we keep our residents safe? How do we keep our own employees safe? And what are all the variety of things that could go wrong, and helped guide us through that. We also, in talking to them, they reviewed our current coverage and determined, and talked to our insurance provider, and it was determined that we needed additional insurance to undertake this work. And that was because our then current insurance didn't cover the like professional medical services that some of these folks were now going to be providing. So insurance is number 2. Number 3 is training. Again, depending on the community, the needs of that community, the breadth of your program. Amos gave us a really good definition of community responders, but even within that definition, there's a lot of different forms these programs can take and the types of calls that they can answer. And so for us, beyond mental health crisis calls, we also included loitering and trespass calls, which were areas of law that clinicians don't know about, right? They don't necessarily know the law of trespass or loitering or panhandling. And so as we started to shape our program, and in the 2.5 years we've had it, we've realized we need to provide additional training to folks for them to understand trespass and what can we do as government officials and them as non-sworn government officials when dealing with potential, a business owner wants to trespass somebody. So training. So be flexible, take on new training. Don't assume that the onboarding in the first few weeks is going to cover everything. Come back to folks as you're shaping your program. I've provided training to our entire staff on trespass issues, of course, Fourth Amendment issues, welfare checks, and the law regarding welfare checks. And that's now included in our onboarding. So the 6-week onboarding process, I make sure to train everyone that comes in the door on those topics. We're developing training for other areas, such as when First Amendment auditors and how our folks might deal with First Amendment auditors when they're coming into contact with folks obstructing sidewalks and public rights of way, right? There's a lot of laws that are wrapped up in that we don't immediately think of when we think about mental health crisis response. So policies, training, and insurance are ways that I think municipalities can better protect themselves.
Thank you so much for that. We won't call it advice, but that helped. Now we've covered the first section of the webinar, the main takeaways from the report, and we're moving into the second portion, questions that audience members submitted in advance. So Jay, I wanted to put the first one to you. Do cities face significant liability risk if community responders have slower response times to calls compared to police who used to handle those calls?
So I think the best way to answer this question is with a general overview of generally no, but there's a lot of assumptions built into that. It's probably the easiest way to answer it. If you're assuming that a call triage system is working appropriately and asking the right questions for the situation that's presented to the call taker, then I would say generally no. So by design, the community response system is going to be going to lower acuity calls. Those automatically are triaged into slower responses, public safety workers getting there to address the situation on a non-emergent basis. During the course of travel there, if a higher acuity call comes out, then the people can go respond to that. That's built into any system that has a limited amount of resources. I think probably a key component to any community response system is what the training of the dispatchers is going to look like in this particular model. And that's going to be a key component. What are the questions that are asked to decide what level of response should be addressed to the situation? Can it go to community response? Does it need to go to police? Every situation is going to be unique. Every situation is going to have its own variables that are going to dictate who is going to be sent to that as the best person to address it. generally speaking, as long as the situation remains stable, and what I mean is that the particular issue that's drawing 911's attention to it doesn't change greatly, and it's still determined that a community response is an appropriate avenue for it, I don't really foresee any problems with slower responses. The issue is going to be, is the dispatcher getting an accurate picture of what the situation looks like? Can they appropriately ask all the questions to address the key variables? One thing I think that probably needs to be emphasized here, and I know that you had mentioned it at the outset, which is these are non-armed individuals going as representatives of the local government, is the fact that they're non-armed. I don't, you know about other community response systems, what those individuals can do to protect themselves. But really, the overarching model within any public safety agency is that there is no duty on the responder's part to put him or herself in a dangerous situation. And because of that, I think a community responder who's going in with basically no self-protection, and that's designed by the job itself, that person could be potentially taking a risk. I'm talking about the government worker, not only the risk to the person who is brought to the attention of the government agency, but also to the worker, him or herself. I know this is a rather long answer to what your question is, but I think these are all variables that need to be taken in, and it sort of re-stresses the ultimate thing I said here, which is hopefully the dispatcher is asking the right questions, getting the right information. There is going to be no potential threat to either the individual who is the subject of the 911 call or the greater public or anything like that. And therefore, a slower response time would be justified under those situations.
Thank you so much. And I know with any question, no need to apologize for the depth, because this is why the audience is here, and we know that you could have gone into far greater depth than you did. Kurt, the next question I wanted to turn to you. If a community responder program gets official first responder designation, does that provide additional liability protection, and does that answer vary by state?
Yeah, so in the context of tort liability, whether or not a program or an individual has a particular designation, that's unlikely to be dispositive or to change sort of the analysis, unless the statutory scheme in that state requires it, or the regulatory scheme in that state requires it. This is not something, we didn't come across this issue at all in the research. And most states that expressly provide for limited liability by their statutory scheme tend to specify either the governmental unit, so fire department or fire services, emergency health services, 911 response services, or actions in that governmental action context that we discussed in the first half of the presentation today, as opposed to certification sort of providing the baseline. That said, if a state has a regulatory scheme that requires certification or designation, or requires additional requirements for people to participate or to be certified, that could present alternative regulatory risk. But in the tort context, it's unlikely to make much of a difference. That said, again, if there's a requirement that a city employee, in order to respond, have a designation or be certified in a certain way by regulation in that state, and someone's hired who is not, that could be a factor that complicates the analysis as to whether or not the city is sort of living up to its expectations in that regard. But as far as tort liability goes, it's unlikely to make a change.
Thank you so much. I have a somewhat related question for you, Sofia. So If a city begins sending community responders rather than police to mental health related 911 calls, would the city be legally required to hire community responders with mental health credentials?
Oh, good question. I have not seen a clear answer on that, right? Just because we don't have a lot of laws on these issues already. And so, I mean, I do think that the cases that I mentioned in DC and Washington County might shed some light on this, depending on what they hold. Perhaps one of those lawsuits will say, hey, equal treatment of folks with disability under the ADA and Rehabilitation Act means that, just like you said, trained and certified EMTs or paramedics to certain physical health issue emergencies, you also have to send trained and certified staff to deal with mental health crisis calls. So we could see that. We could see that the case law, these cases kind of flesh some of that out. I don't know if they'll get that specific. So I have not seen something like a blanket law that says if you do these programs, they have to be folks that are certified in XYZ ways. But I do want to note that, of course, there are lots of state laws out there. Not that I've researched all the state laws because I'm in my little corner in North Carolina. But you may have state laws that provide some specific limitations as far as who can be dispatched to EMS calls or medical health calls. Insurance coverage may mandate some specifics. Your insurance provider may say, okay, if we're going to cover this, you have to have folks who are certified to provide this. So yeah, sorry if that's an unsatisfying answer, but I haven't come across, and I don't know if Jay and Kurt have any law that nails this piece down.
Kurt, you shook your head, but I wanted to just put that to you because you did lead the national research looking at these types of issues for the report. If you came across anything that would suggest there was a legal requirement that to handle mental health calls, you need to have mental health credentials.
Yeah, we didn't come across anything, though that's not to say there isn't one out there, as Sofia said. So, but in term, and we did a pretty good, looked at a pretty good number of cases across 50 jurisdictions, and that has not come up. So it very well could be one of those things that we'll almost have to wait and see where the law develops in that front.
Thank you. Sofia, following up on that previous question, do cities reduce liability by mandating that community responders have specific credentials such as LCSW or paramedic?
So again, speaking just to Durham, I think, once we decided we were going to do this work, then thinking through what responsibility we have to do the work safely and to take caution to provide safe and good services. And so asking ourselves, do we think the work can be done and done well by non-certified staff? And why do we think that? Do we have good data on our side that shows that? There wasn't a lot of data out there, right? So then trying to be more cautious and also trying to, when you're trying something new, I think it's important to, when you're stepping out, and Durham certainly was one of the first in the nation, but certainly in the state, it felt more of the balance between risk and liabilities and what we were trying to provide. It felt like the safer approach for us to say we want folks that are certified in these different areas that we're going to be responding to. So for us, we have peer support specialists, which is a state program, and they receive a state certification to be peer support specialists. We have clinicians and we have EMTs, and all of those have like state certifications because, again, doing something new, it felt like the right thing to do to have those kind of folks doing the work that have generally accepted professional standards that say we're going to follow.
Thank you so much. Jay, I wanted to turn slightly to community responder teams that employ EMTs or paramedics and ask, what is the threshold for becoming a patient rather than just another person that the responder encounters?
So the threshold for becoming a patient is set by medical protocol on the or for whatever the jurisdiction is. So that's going to be worked out by a medical director or a panel of medical directors. Someplace I know from personal experience, I can't speak for everywhere, obviously, but the threshold is generally very, very low. Typically, if someone calls a 911 center with a medical complaint, that's really all it takes to become a patient at that point. Um, there's some gray area if a third party calls for another individual, um, that the person who's identified as a patient at that point may or may not be a patient. That depends on a number of circumstances that are assessed at the scene when examining the person. Even if the person wants to be examined, that's a whole other factor that needs to be taken into consideration as well. I know that at least in the agencies I work for here in Colorado, um, the threat, if the person is what we call alert and oriented ×4, which generally means name, location, time, and what I call a simple processing question, that they can answer. If they can successfully pass those 4 hurdles and they tell me, I'm not a patient, go away, I have nothing really I can do at that point. I have to go away. So the question of whether a person is a patient or not a patient, again, that's going to be set by local rules and rules set up by medical directors. It's not really anything particular to a statute or anything like that. There may be some directives from a state health agency that may guide on that question, but again, that's going to come down to a medical direction question.
And if I can jump in there, Amos, too,
Yes.
I wanted to highlight too that just like what is for EMTs a patient, that may also look different for clinical social workers, right? And how a patient relationship is established. And so that may be a different set of medical protocols for EMTs, but maybe like professional regulations for social workers. So it really is multifaceted as far as what you're thinking about who is going to be engaging with the resident, what are they going to be providing, when do they become a patient or not, and what duties does that then put on the city and the responder in light of that establishing of that patient relationship. And for us, it's definitely different. Like the confidentiality that EMTs owe is different than clinical social workers, right? And so there's a lot of things to think about when thinking about when is it a patient and what duties are owed.
Thank you for adding that. I will turn it right back to you with the next question, because similarly talking about these relationships, could a city establish additional liability by conducting regular follow-up check-ins with individuals involved in calls like the Familiar Neighbors program, which could possibly constitute case management or another relationship?
I mean, yeah, I think anytime that you're expanding what you're doing and expanding or growing the amount of times you're going to be encountering someone or engaging with them, there is more possibility for things to go wrong or for liability, for relationships to be established that could then set up some more duty to that person, if you will. So for me, I like to think about, are we wading into territory that's outside the city's jurisdiction? Remember, I began with cities have the opportunity to do certain things, they decide that, but there are certain things cities cannot do, at least in North Carolina. There are certain things that counties are given the task to do, and we're not kind of allowed to wade into those waters. And so first and foremost, the question is, are we going into social services, and can we do that? So can we do it? And if we can, then how do we do it in a way so that we don't lose governmental immunity, right? As Kurt said, that, providing a government function as first responders, that's a pretty known quantity. But if you're going into long-term care, things that look like case management or mental health, sort of psychiatric services, then you may be wading into things that aren't considered government functions, and then you lose that immunity. And so I think for us, when we approached that, we said, okay, we're going to do that. We brought in a lot of stakeholders, and it's a collaborative project where a lot of different folks who have different mandates and services coordinate together, sort of that coordination of care, rather than us taking it on solely.
Thank you so much. Really interesting. Kurt, I want to back up with a question, another audience question. So community responder programs are similar to EMS and fire departments. They're unarmed responders handling 911 calls. How are community responder liability considerations different from those for EMS or fire?
Yeah, this is definitely going to be one of those that varies significantly from state to state and is largely going to be impacted by the state's statutory scheme and also probably how the community responders system is set up in that particular city or that particular state. So I'm thinking like a state like Texas, for example, where in 2013 they made substantial revisions to their civil practice and remedies code, where they actually codified 36 areas of government where the state of Texas waives immunity to tort claims for the municipalities. And they include among those 36 police and fire protection, health and sanitation services, the operation of emergency ambulance services. So if the community responder program in a city in Texas were to be housed within one of those units, for example, the protections of the liability analysis would likely track very similarly to how the fire department or EMS responses are handled in that state. However, if the community response system or community responders program is set up outside of one of those enumerated carve-outs, the analysis might be more ambiguous as to how that would go, particularly in a state where it's defined by statute. Some of the other states that might fall in that same mold are like Massachusetts, like we identify in the report as a very statutory heavy state where they carve out or carve in liability. In a state like Arizona, though, we have the Court of Appeals there, or one of the courts of appeals there, held that where police are performing a caretaking function, so it's still a police department that otherwise would have maybe some protection in liability, but where they're performing a caretaking function as opposed to a police function, plaintiffs only need to prove ordinary negligence and not gross negligence. At the same time, there's a separate Arizona statute, 12820.05C, that indemnifies a public entity for negligence of a public officer who, quote, renders emergency care gratuitously and in good faith on public property. So in that instance, the who and the where may be a factor in the liability analysis. So I think to answer the question more generally, whether a community responder or a city is reliable for the action or inaction of a community responder will be liable will probably depend on questions of fact as to the response that's being provided, and also perhaps even where that response is being provided. The fact that the call came through 911, for example, though, won't be determinative. It'll really be the specific facts.
Thank you, Kurt, and for the additional details on Texas and Arizona. I wanted this is a question to turn to both Kurt and Jay. So there are many cities that contract with service providers to staff their community responder team. They're not city employees. So would contracted responders enjoy similar liability protections compared to city staff responders? So Kurt, I'll turn that over to you first, and then I'll add a tiny piece to it and hand it to Jay.
Okay. Yeah, I will say, generally speaking, for what we encountered in the research, most states that had either cases on this issue or statutes that covered this issue of whether contracted services would be treated the same or differently than actual municipal employees, so people who are hired directly by the city, tended to treat them the same. That's not universal, but many sort of where the analysis fell in a lot of the cases was, again, on the function being performed rather than the form of contract. So the idea of if it was being performed as part of the governmental response, it often didn't matter if it was contracted out or if it was an actual employee. A lot of the cases where this arose was in the hybrid sort of public-private hospital context. So where the court was either analyzing the nature of the employment. These scenarios usually involved like a private, independent contractor doctor hired by a public hospital, right? So they're performing the function for the public hospital, but they are themselves performing, they're a private doctor, so otherwise would be subject to sort of normal medical malpractice. And a lot of the courts, in analyzing or at least in discussing the issue, if they didn't find a way to decide on other grounds, they tended to conduct the analysis that it was the manner in which it was presented to the public. So if it seemed that it was a government-provided hospital, the more favorable government immunities tended to apply. If it did not, well, the question might be different. I will say there's a however here as well, because, for example, there's an Oklahoma statute, Title 51, Section 155. The state actually expressly carves out liability for the acts or omissions of an independent contractor or consultant. So Oklahoma may treat something differently, specifically based on that statutory provision.
Thank you, Kurt. And Jay, I wanted to give you a chance to add anything you wanted here. There was an additional piece to the question, which is how is this different from contracted EMS services? So anything you'd like to add?
So basically adding on to what Kurt already discussed, and Kurt's done far more research on this topic than I have. So I kept mine specific to Colorado, where I reside. The Colorado Governmental Immunity Act, which is 2410-103, specifically does not name independent contractors as public or within the realm of public employees who are covered by that act itself. So if you have an independent entity providing a government function, an independent entity that's private in nature, they would not be covered under that act. So therefore, it would add a layer of liability for a private business that's in fact providing services within this state specifically. As Kurt stated very well, you're dealing with 50 states, 50 bodies of law, and they're all going to be unique in their own way, shape, form, and one might look completely opposite of the other. So that's why if you're setting up a community responder program, you have to be aware of those issues, especially if you're considering a private entity that's going to be dispensing that particular service. If I was advising a private entity in a state where they were exempt under the immunities protections of that particular jurisdiction, I know I would be telling them, and this is sort of dovetailing, on what Sofia said, get lots and lots and lots of insurance. It's probably going to be your best protection.
Thank you so much for that Colorado specific detail. Sofia, turning back to you. So in the event that a negative outcome does occur, it seems important to be able to document that a city's program has been running smoothly and safely, or has been updated in response to lessons learned. So in what ways could data collection, sharing, and transparency be an indirect way to minimize cities' liability in sending community responders?
Yeah, data's your friend. Be very good with the data. So, I mean, certainly having data is going to help combat direct causes of actions that may arise, such as someone saying this bad thing happened because the city failed to adequately train its employees, or because the city failed to adequately supervise its employees, or because the city was negligent in that supervision, right? Those are three causes of actions that someone could claim directly against the city. So if you have data that shows that this is an outlier or that the city does respond to arising issues in an appropriate manner and with the right gravity, that's going to go a long way to defeating those kinds of claims. Certainly also data is going to help to combat, Monell liability, right? Monell was a case, but it was regarding what Jay mentioned, 1983 claims, which is when an employee acting under the color of law violates someone's federal rights. So those are 1983 claims. And the organization can be on the hook for an employee violating someone's federal rights if the organization has customs or practices in place that kind of, whether it's promotes or allows or causes the concerning behavior. So having data that says we don't have those policies in place, or, oh, look, when an issue comes in the door, this is how we dealt with it, and this is our track record. All of those things will hopefully show a good side and help combat those potential both vicarious liability claims as well as direct liability claims against the city. So data is your friend. Data also helps, as we talked about with policy tweaking, right? We go back and look at the data and to determine, did the policy we have in place have good outcomes, and what do we need to change accordingly if there does need to be some tweaks.
Thank you so much for that. Love that. Data is your friend. Kurt, again, I will also give Jay a chance to add on here, but just to start with you, what is the level of liability for a clinician community responder if a patient has been determined to be in need of hospitalization because they're an imminent risk, but the patient absconds while the clinician is waiting for a police or EMS transport?
Yeah, so thinking about this one again in the context of a community responder program, my understanding of the model is that there's not really going to be any ability for the responder, whether clinician or not, to detain the individual or to keep them sort of under wraps. So I think this would end up falling under the ordinary rubric of no liability for failure to prevent harm that we discussed in the report and at the outset. Because we didn't do it in the research, and Jay may have more experience with this, specifically as to some of the duties of EMT or EMS work in this space. But otherwise, I don't see anything here on these facts alone that would sort of change the analysis that we discussed in the report. That said, and the caveat we threw in a couple of places in the report and I discussed today, there are those cases in New York, DeLong, and Washington, Newark, where either the decision to undertake the provision of medical care may not itself be a government function and thus falls out of that analysis, or DeLong, where a series of other factors, not just the fact that someone absconds or leaves, but other factors as to the interaction contribute to a different analysis there.
Thank you. Jay, anything to add on that one?
Not really much. I think a lot of this is going to be dictated by the shape and form of what the community responder program looks like. And what I mean by that is, and I know Sofia was talking about this. Do you have, licensed social workers responding? Do you have, counselors? More people who are prone to discussion to try to handle the situation versus trying to carry out medical interventions that could, potentially handle a patient who is clearly having a mental health problem, needs hospitalization, but is resisting those efforts. One of the places, where I work, in addition to Colorado, I work in a city in the Midwest. I travel there. We have, not only training in terms of, basically analogous to the crisis intervention team training that police have trying to resolve a situation, but I also carry a whole group of medications where I can deal with a situation, and assuming that I have the right number of people to assist me, I can, for lack of a better word, sedate a person so that they don't abscond and that they can get to where they need to be treated. Under those particular facts and circumstances, yeah, I think I would have a higher, duty to try and manage that situation better so that person gets to where they need to be. But if the crisis or the community response team doesn't have those, I mean, ultimately, I fall back to what I talked about earlier. There is no duty on a community responder to put him or herself in danger to try and manage a situation. If that person is looking at harm, they just have to let the person go. And I don't think any court is going to find that that person was negligent in any way, shape, or form because of the potential for harm.
Thank you so much for adding that on. That's really informative. Kurt, so what is the level of liability for an EMT community responder if a medical emergency occurs nearby? So just to give some context, this person shared that EMT responders had been in the field when a medical emergency occurred in their area, and then they were required to render aid until an ambulance arrived.
Yeah, so in the context of liability as it would apply to the city or the municipality itself, this is going to fall under some of the discussions we had previously. For example, as we mentioned in the context of an earlier question, in Arizona, there's a statute that actually protects public officers, which would include an EMT here, who are rendering emergency care from negligence liability when it's done on public property. I know we didn't specifically examine EMT specific statutes in the research, but there are a number of states we came across where they provide for indemnity or carve out medical care in the same way that they do firefighting or police response. So in those states, it would be a similar analysis. But again, I go back, and I've probably quoted this case now 4 times today on the presentation, but I go back to the Washington case of Norg v. Seattle, where again, they came, it is an outlier case amongst what we found, but they came to determine that once the emergency medical response was being provided in some form, it was no longer a government function, and it became sort of your ordinary tort liability analysis of just negligence standard. That said, and this is an area where, again, it wasn't part of our research in the report, but many states do have what are called duty to act laws. And these often specifically apply to EMTs. I know New York has such a law, and though it doesn't compel an off-duty EMT to render aid, it does kick in once an EMT begins engaging in the administering of care. There's a duty to continue servicing that patient until it can be transferred to another appropriate party, a doctor, a paramedic, or whatever. So as to protecting the individual EMT, Good Samaritan laws in many states would apply to the EMT. Generally, they provide liability protection to the individual, though. I don't know the extent to which they actually would extend to the city itself. But the duty to act and Good Samaritan interaction probably applies to EMTs in a number of states that live in the same way that New York does. But someone who deals with that more regularly may have more detail on that.
Yeah, and if I could just jump in, something else also to consider when we're talking about EMTs, we're using that term pretty freely, but right, there's different levels of that. For North Carolina, EMT basics, EMT advanced, and then paramedics. And so when we were thinking about who do we employ, there are different levels of, for example, medical malpractice. Paramedics can be held liable for medical malpractice, but in our states, EMT basics and EMT advanced cannot, right? So we're thinking again about tort liability and who we're going to bring in the team and what services they're going to provide. Think through those things as well. Like, is this also a potential source for medical malpractice? And what kind of insurance then do we need to consider when we're thinking about malpractice insurance for medical professionals? So just wanted to throw that out there as another thing to consider.
Thank you both so much for giving that level of detail again. Sofia, I wanted to jump to you for the, obviously our report focused on 911 calls, But what about calls that come in through 988 or suicide prevention hotline? Would those be treated similarly for liability purposes as a governmental function?
So I can't speak to the suicide prevention hotline because I don't, those can be established in different ways and perhaps by nonprofit organizations. But 988 is likely to fall under a governmental function, right? It was established by federal law from funds from the U.S. Department of Health and Human Services. It lives in the Substance Abuse and Mental Health Services Administrations. Yes, that the SAMHSA does then contract with, I think the organization is called Vibrant Emotional Health, which is like a nonprofit to coordinate the 988 network. But like Kurt mentioned, it doesn't really come down to, is it a contractor or not? Usually it comes down to what is the function that is being done. And so I do think that 988 would likely fall under governmental function. And I do believe that the folks at Vibrant and SAMHSA are working with municipalities and counties across the country to try to develop interoperability between 988 and 911. And just again, for Durham in particular, I don't have concerns about us pursuing that and 988 being another source of dispatch. I see it as expansion of service, but all within sort of that same bucket of services that would fall under first responders and a governmental function, excuse me.
Thank you so much. A lot of people are very interested in 988 questions. Jay, I wanted to ask about, so for 911 calls categorized as medical calls, what is the role of the medical director? You referenced medical director earlier, and is there a liability for the medical director's choices in creating the rules?
The medical director plays a great role in establishing how medical direction happens for an agency overall. In fact, you can almost consider that person the king or the queen or the president, whatever label you want to put on that individual. They are or that person is the individual who sets up the protocols under which all EMTs and paramedics operate. They provide the guidelines. Protocols are more, I don't want to present them as rigid rules, but they are strongly recommended courses of conduct. How about that for the people of an agency? So speaking specifically in terms of mental health calls, that individual is going to at least set out how that call should be handled in a medical sense. And it's been in terms of every agency I've worked for, the medical director is an emergency room physician. I am unaware of how much consultation medical directors do with mental health professionals when deciding how calls that involve psychological or mental health emergencies evolve. And they really are, generally speaking, from my experience, pretty poor about how they or how EMTs and paramedics should handle calls, short of actually having to go to things like restraints or medical restraint or what we call chemical restraint or anything like that. It's generally left to the EMS agency training directors to provide direction to the EMTs and paramedics to come up with systems, processes, tactics, strategies for handling patients, short of dealing with or short of doing those measures that I just discussed. Some agencies do much better jobs than others. Like I mentioned before, the one city that I work in the Midwest, St. Louis, they have a 8-hour CIT program where you learn how to interview people, have conversations with them, try to get these individuals to the appropriate level of care. Then I've worked for other agencies where there's absolutely nothing. And it's up to you to have to come up with your own body of knowledge. If you face those particular calls, you have to go to continuing education classes, do your own research, et cetera, et cetera. If I had to provide an overall assessment of EMS in that area, I think it could use a lot of improvement.
Thank you, Jay. And yeah, it sounds like it certainly could in a lot of places. So we just have a couple more questions. Thank you everybody for sticking with us for this this whole webinar. Sophia, we have a lot of interest here in insurance. Does liability insurance for a community responder program, in your experience, create a significant financial burden for the city? How does it compare to liability insurance for other city programs?
So I don't know the exact amount that we pay or how much additionally we pay for insurance. They don't let me write the checks. That's outside of my wheelhouse. But I do know that we needed to get additional coverage for the services that we were seeking. I saw in the chat too that someone else noted that they went to like an insurance marketplace and had to kind of cobble together some coverage. And so I think it can look different based on the providers that you're working with. Durham is a fairly good size municipality with a lot of employees. We've got some pretty well-established relationships with our coverage providers. So we were able to stay with the coverage, the companies we were already with, and to add that coverage. But maybe for smaller municipalities or very small departments, you might need to be shopping around for this coverage. And yeah, maybe some folks may be reticent, again, because the service is still considered fairly new across the country.
And one question, one more for you, Sophia. Once an involuntary hold order has been issued by a court, and that has different names in every state, can community responders do the transport without having to involve the police?
Ooh. That's a big question, and it really is so state dependent, right? Because it's state laws that dictate what, in North Carolina we call them IBCs, involuntary commitments, what those look like. But I think so. For us, there's state statutes that say this is what the process is like. And it starts with some sort of petition to a magistrate's office that says this person is a danger to themselves or to other, or why the involuntary commitment is necessary. At that point, there is a form that the magistrate signs that says, hey, law enforcement, go and transport this person. What we have found is, unfortunately, our statutes don't say it has to be a law enforcement, but the form does. So we are currently working on trying to, with the administrative office of the courts, to try to get the form updated. We're trying to like almost write a memo for the magistrate's office to educate them on, like, even though the form says officer, it doesn't have to just always be an officer. And we're working with our local hospitals and our managed care organization to enter into what's called a transportation agreement that is ultimately going to allow for our community responders to provide these transports. But as you can tell, there's a lot of moving pieces. And so even though our laws allow it, the form is outdated. You have to educate folks. You have to bring in stakeholders. So we're in that process. I imagine if a state as conservative as North Carolina allows for transport of by non-law enforcement officers, there's a lot of other states that also allow for it. It's been an uphill battle for us. It's been something we've been trying to work on for the last 2 years. But we're working on it. And also on involuntary commitments, I want to mention too, that part of that process usually involves what's called the first examination, where, you have the petition that the magistrate has signed that says, yes, this person needs to be committed involuntarily. But then there's a first examination, and that's actually with someone who is certified to do these, whether it's a psychiatrist, a licensed social worker, et cetera, that actually gets eyes on that person and does an exam to say, yes, in fact, they should be taken in. We're also working on having our folks, licensed clinicians, do an in-field examination. So maybe for some of those, when they do that, we determine actually no transport is necessary. And we can kind of dispatch with those calls and maybe connect that person to other services that aren't as severe as involuntary commitment. So there's a lot of there's a lot I could talk to about involuntary commitment, but great question.
Wonderful. With that, we are coming right up on the end of the hour-and-a-half session. So thank you again to our panelists, to the audience members who submitted questions. And again, we want to continue this conversation. So with new questions, concerns, other feedback, please send an email to liability@lawenforcementaction.org, and we will do our best to respond to everybody. We also hope to be able to make the recording of this webinar available if you missed the beginning or parts of it. Hopefully we'll be able to follow up next week with that. And we'll also in that message provide an opportunity to stay in touch with LEAP for announcements about future liability related or other community responder projects. For example, we'll be publishing a nationwide map of existing community responder programs in early 2025. So we'd love to stay in touch with all of you about those projects. So again, thank you for joining us. Please join me in giving our panelists a thunderous yet silent round of applause. Hope everybody has a great rest of their day.